Good morning, everyone. So, on behalf of the management, principal, staff, and biotechnology, electronics and communication engineering, I welcome you all to the workshop on design thinking and innovation. So, today we are having with us Dr. Girija Sriram, an IP specialist, patent attorney, and founder of iParty Entity IP, and she has over a decade of experience in intellectual property laws and practices. She focuses on handling issues related to patent, trademark, copyright, design, including searching, drafting, prosecution, licensing, monetization, and counseling clients on addressing IP management and formulating IP strategies. Additionally, she is also a seasoned speaker and talks about intellectual property related matters at various conferences, academic and research institutions and corporates. Ma'am has a master's degree in science and she holds PG diplomas in IPR management and business administration. Ma'am is an expert panel member of the WTO and Relay Cell of Vishweshwaraya Trade Promotion Center, Government of Karnataka. She is empaneled as patent attorney and consultant for various institutes and colleges. She is also a facilitator for startups in patent, Government of India. Ma'am, on behalf of the principal, management, staff and students of the Department of Biotechnology and Electronics and Communication Engineering, I welcome you, ma'am. The forum is open to you, ma'am.
Thank you for that nice introduction. Yeah. So shall I start sharing my slide?
Yes, ma'am. Sure.
Yeah. Are you able to view my slide?
Yes, ma'am. Yeah.
So shall I start my session now?
Yes, ma'am. Sure.
So I am audible and my slides are also seen. Na? Okay. Good morning, everyone. So in this session, I'll start with overview of intellectual property rights. And then I'll move to the patenting procedure, industrial design registration, and finally I will take up the questions. I would like to receive a number of questions from you and I want to devote ample time on discussion. So this overview of IP rights is just a warm-up session. I just want to brush up your knowledge on the IPR. Actually, I thought like we will have an interactive session and I called Dr. Indulekha ma'am and then found out that it cannot be a dialogue part of this session. Only I can deliver one way. It's a one-way session. So I'll just focus on the important facets of IPR. So let me start with the short meaning of what is intellectual property. So intellectual property is used to describe the results of creative and innovative endeavors. So we call it as intellectual because it is created by the intellect of the human mind, and we call it as property because like tangible property, this intangible property can also be owned, sold, leased or transferred. See, what are the ways of protecting IP? Innovative products and processes, you can protect it through patents. And brands, you can get registered under trademark. Literary, artistic, musical works, photos, you can protect it under copyrights. Creative designs under industrial designs. And indication of origin, that can be protected under geographical indication. Any confidential information which you do not want to share with others, so you can keep it as a trade secret. And the layout designs can be protected under Semiconductor Integrated Circuits Layout Design Act. A single product can be protected by many IP rights. I have just taken a common example of a pen. So the pen as a product, you can protect it through patent. So the name of the pen, it can be registered under the trademark. The composition of the ink which you do not want to share with others, so you can keep it as a trade secret. The style of the writing, you can protect it under copyright. The whole aesthetic look and the feel of the pen, you can protect it under industrial designs. So first we will see I'll give a short introduction to the different kinds or the different phases of the IPR. So the most important facet of IPR is the patent. So what's a patent? So it's a document which describes an invention. Apart from that, what does it do? It creates a legal situation in which the invention can be exploited only with the authorization of the patent owner. The second important facet of IPR is trademark. I think you would have come across trademark in day-to-day life with your starting with your mobile phone and to the many things, the car, the brands are seen everywhere with the dress and everything. So it is a sign that distinguishes the goods of the services of one person from those of the other. So the trademark, you would have seen, it can be a word or it can be a logo, or it can even be a combination of a word and logo, which we call it as a device. Even a number can also be registered as a trademark. The shape of the goods and colors can be registered. Sound can be registered. Even the smell is registered as a trademark in foreign countries, but in India it is not possible. And so I just want to share a sound trademark, a famous sound trademark, the Yagoo's Odal, which has been protected in India. And I think you would have also come across with the trademark. Along with this, you would have seen this a TM sign and R sign. So TM is that when the application is just filed, you can start using the TM along with your brand name. And when it gets registered, you can use the word R over your brand name. What are the types of trademark? There are 4 types: certification mark, service mark, collective mark, and trade dress. So what's a certification mark? See, this is normally used to certify their goods. So I have just given an example of ISO 9001. And service mark is generally used in service industries like an Indian airline or a bank sector or an insurance sector. And collective mark is normally owned by organizations like Lions Club or the Rotary Club. And trade dress refers to the total package of the goods. Third important facet of IPR is trade secret. I think you all may know the trade secret. Whenever a trade secret is told, the Coca-Cola formula comes to your mind. So what is it? It is a confidential business information that provides an enterprise with a competitive edge. So as I said, a very classical example for a trade secret is Coca-Cola formula. And not only the formula of producing goods has to be kept as a trade secret, even people keep the financial information, data compilations, and the manuals of important operation of important devices are also kept as a trade secret. So the main important characteristic of trade secret is that you can protect it without registration. And again, an important characteristic for an unlimited period of time. See, what are the elements of a trade secret? See, it should have an economic or a commercial value and it should be independent. And generally, when we say secret, it should not be known to the others. And reasonable measures should have been taken by the trade secret holder to maintain the secrecy. So this is normally done legally in a form of a non-disclosure agreement. Other important facet of IPR is GI. So GI is a sign which is used on the goods that have specific geographical origin, and it possesses the qualities or the reputation and also the characteristic that are attributable to that place of the origin. And again, you would have come across many GIs and Karnataka stands first in number of GI registered. So I think there are 432 GIs so far has been registered in India, and I have just taken few examples from different directions of our country. And normally the GIs are classified under 4 category. It can be an agricultural good or an handicraft or a foodstuff or a manufactured good. So I have taken an example of a Darjeeling tea for an agricultural category, and Kullu shawl for handicraft, and Dharwad peda is again the foodstuff, and the Nashik Valley wine for the manufactured category. Copyright. So I can say that the very three important IPRs which are relevant to the academicians, or maybe the first one is patent, and then industrial designs, especially to the people in the domain of engineering, patent, designs, and also copyright. Why I say copyright is that, see, with the artificial intelligence blooming up, see, many people, they come up with the algorithms. So these the source code or the object code can be registered under the copyright, and we have done many source code and object code get protected under copyrights for engineering colleges. So what does a copyright does? It protects the creative works of the authors. Who are all the authors? The authors are the writers, the artists, the architects, the photographers, the directors, and also the music composers. What are the works that can be protected under copyright? It can be a literary work. So again, as I said, that computer program, you can protect it under the literary works. So in this case, this literary works becomes more relevant to the engineering students. And then a musical work and artistic works, maps, technical drawings, the photos, even the motion pictures, and this is the computer programs, the multimedia products. These can be protected by the copyright. So the copyright, it protects the expression of the ideas. So the abstract ideas cannot be protected under copyright. Again, when I said the expression, you have to express it on the tangible form. And what are the rights a copyright owner has? So the copyright owner has many rights. So he has the right to reproduce, adapt, translate, distribute, publicly communicate, and publicly perform. And there are two related rights to copyright. The one is the performer's right, the other is the broadcaster's right. So what I mean by performer's right, see, if a TV channel, they want to broadcast a live telecast of a dance, then they have to get the permission from the dancer. And what I mean by the broadcaster's right, see, if no person, they can make a visual or the audio recording of a broadcast without the permission of the broadcaster. So these are the two related rights to the copyrights. Industrial designs. As I said earlier, so the three important facets of IPR, which are very much in relevance to the engineering domain, or the patent, industrial designs, and copyrights. So industrial designs, how the industrial design differ from the patent. See, patent protects the functional or the utility, whereas the industrial designs protects the aesthetic aspect of the article. So what does it it protects? It may be the aesthetic aspect can be a shape, or it can be a pattern, or it can be a ornamentation, or it can be a configuration also, the arrangement of the parts, or any other artistic aspect. So if a design has a functional or the utility value, you cannot protect it under the design. So you have to protect it under the patents. So I have just given an example of a car. See, we have come with a new shape of a car. So if that shape of the car improves the fuel efficiency, then you cannot protect it under the design. You have to protect it under the patents. So any aesthetic design can be protected, which is applied to the article through industrial means, can be protected under the industrial designs. Semiconductor integrated circuit layout design. So this is one of the IPR which is very least utilized and explored by the engineering domain people. See, I just went through the report which has been published by the Intellectual Property India. So I found that only one application has been filed under this IPR. So it's a very much less explored by the engineers. So what is this SICLD? So it is governed by Semiconductor Integrated Circuit Layout Design Act 2001. So what I mean by layout design? So layout design means the arrangement of the transistors and other circuitry elements expressed on a semiconductor integrated circuit. What is the criteria for registering a layout design? The first one, it should be original. Original is that it should not have been a copied one. And again, distinctive. Distinctive is that the design should be distinguishable from the existing designs. And it should not have been commercially exploited, either in India or any country which they are party to the Paris Convention. And the term of protection of this SICLD is 10 years from the date of filing of an application for registration. So having seen the term of protection for SICLD, we can also see the term of protection of the different IPRs. So how long you can protect a patent? Only for 20 years. That too from the date of first filing of the application. But every year you have to pay the renewal fee to keep it alive. Whereas the trademark and the GI, they are perpetual. They are, once you register the trademark, it is protected lifelong, and you have to pay renewal fee every 10 years again to keep it alive. And copyright, the term of protection in India is 60 years plus lifetime of the author. I think it covers the entire time period. And there is no, again, a very important advantage of the copyright is you need not pay any renewal fee. And the industrial design, the term of protection is only 15 years, the 5 years less than the patent. Initially, they will grant the design only for 10 years. So once before the expiration of the 10th year, you have to pay the renewal fee to keep it alive for the next 5 years. I would like to share this slide to know about the trend of IPR filing applications in India. And that too I have taken the last 5 years. And if you see that in the last 5 years, there is a consistent growth in the number of filing of the applications. And we have got an update on this information up to 21-22 till last year. And you can see nearly 5.68 lakh applications have been filed, which is a 7.5% increase over the previous year. And in this, you can see the lion's share is occupied by the trademark, followed by the patent, then copyright, and then design, followed by the GA. And you can see that design, the number of applications have increased stupendously than the other IPRs in the last year. So just having a warm up on overview of IPR, which is very much essential to go into the important aspects of patent and design. So this patenting procedure, I'll just walk through a short introduction to patents. Then we'll see the very important aspect of patent, which is the patentable and non-patentable subject matter, or we call it as the checklist to know whether it is patentable or not, and the contents of the patent specification. We'll see the nuances of the specification, which is very important to understand how a patent looks like, and also the patent filing mechanism. Introduction to patents. As I shared earlier, the patent is a legal document which describes an invention, and it also creates a situation where you can exploit the patent only with the authorization of the patent owner. Otherwise, it amounts to infringement. And how long the patent gets protected? Again, I shared it is protected for a limited period. So it is for 20 years from the date of filing of the first application. Why should I go for a patent? So the main aspect of the patent is that you can protect your invention. You get an exclusive right. And again, you get an commercial return over it. So for these three main aspects, we always advise to go for a patent. Is patent necessary? So my answer will be a big yes. Why? To encourage research and development, to stimulate the capital investment in the country, which leads to the growth of the economy, and also it encourages establishment of new industries. So for these reasons, patent is highly necessary. Patentable and non-patentable subject matter. So the main important aspect of the patent is to understand which is patentable and which is not patentable. Okay, what can be patented? So the invention, it must be first novel, and the second, it should have an inventive step. Third, it should be capable of industrial application, and it should not fall under section 3 and 4 of the Indian Patent Act. So what I mean by novelty? See, the novelty means your invention should not be a part of the existing state of the art. It means that your invention should not be in the public domain before filing your application. Prior use and prior publication of your own invention are also the obstacles for granting the patent. So this is a very famous case law related to the novelty. So in this case law, it was concluded that the invention was not itself new. Its combination with the other element of the system producing the advantageous results would be sufficient element of novelty to support the patent. So in short, what they mean to say is that even your invention need not be a breakthrough invention. So even an improvement over the existing product or the process is also patentable. Means it clears the first step of the novelty. Second one is that inventive step or the non-obviousness. So to get to your invention to be patented, the first is that it should be novel, and the second is it should have an inventive step, or we also call that it should not be obvious to the person skilled in the art. So what I mean by inventive step? So to be in plain language, it is that it should have an educate technical advancement. What I mean by educate technical advancement? I said in the previous slide regarding the novelty that even an improvement is eligible for patent. So, but that improvement should not be a workshop variation. So this was the outcome of this law, which is a very famous case law related to the inventive step. They said that an improvement is eligible for patent, but that should be something more than a mere workshop improvement. So you may ask me, what do you mean by the workshop improvement? So the workshop improvement means, see, when you create a product or a process, there may be routine improvements. See, the routine improvements, we call it as the workshop improvements, and this is not eligible for patent. So to prove your inventive step, you should show educate technical advancement in your invention. Industrial application. This is the third quality your invention should possess to get a patent granted for it. It is that the invention is capable of being made or used in any kind of industry. So generally we call it as the utility or the usefulness of the application. So your invention should be capable of being made or used in any kind of industry. And you can see this in this case law where they say that it should be made or used in industry. So it can be for profit or not profit. So profit is not a criteria to determine the industrial application or the utility value of your invention. Having seen what can be patented, now we will see now what cannot be patented, especially in India. Okay. So in section 3 and 4 of the Indian Patent Act, they have listed out what are not patentable. So the first one is, they say that the frivolous invention and the inventions contrary to the well-established natural laws. So I have just given a very basic example in order to understand the concept clearly. So what they mean by frivolous invention? See, merely making in one piece the articles which are already existing in 2 or more pieces. So this is an example for frivolous invention which cannot be patented in India. Again, any invention which is against the natural law. Say perpetual motion is contrary to the law of physics. So it cannot be patented in India. And inventions contrary to the public order or the morality. So you may come up with a great invention of a gambling machine or a device for breaking the house, or you may develop a biological warfare material using a modified microorganism. But these are all contrary to the public order, although it may be a breakthrough invention which may be eligible to get a patent of satisfying the novelty and the inventive step, but you will not get patent granted in India because these are all the inventions which are contrary to the public order or the morality. Again, see, discovery is an enemy to patent. So any discovery is not patentable. So a discovery of a scientific principle or a living thing or a non-living thing, they are not patentable. Again, if you formulate any theory, an abstract theory like a Newton's law, it is not patentable. And again, as I said, any living thing, non-living thing discovery you make, it is not patentable in India. Again, mere discovery of a new form or a new property or a new use of a known process or a product or a machine or an apparatus is not patentable in India. See, I have just given an example. See, already you know a substance which is in the amorphous form. You say that, no, I have come with a new form of this substance in a crystalline. It is not patentable. Again, aspirin, you know, it's well known to people used to take for a decade. You say now I have found a new use of it, which can treat the heart ailment. Then again, it is not patentable. So new use of a known compound or a known drug and a new property or a new form of a known substance, these are all not patentable in India. Yeah, this is highly related to formulation patent or a composition patent. So where they normally come up with the formulation by mixing different components. So whenever you try to come with a formulation or a composition patent, so you have to give the synergistic data. So what I mean by synergistic data? See, as the Indian patent law clearly says that when you get a composition or a formulation just obtained by mere admixture. Mere admixture is that, say, I mix two compounds and I get a new compound. But the mere admixture, you have got such a compound, then it is not patentable. You have to show the synergistic. Synergistic effect is nothing but the interaction between the two components. So how you can give the synergistic data? Synergistic data, for example, I say when I combine A plus B plus C and I get a compound, new compound. Then I have to give data like A plus B, what is the efficacy, what is the efficacy of B plus C, and what is the efficacy of A plus B plus C plus D. So the A plus B plus C plus D, that efficacy should definitely be higher than the other combinations. So in such a way, you can prove that there is interaction between the components and the synergistic property is well established for a formulation or a composition patent. Mere arrangement or rearrangement or duplication of the known devices, each functioning independently. So this normally comes for a mechanical patent. So whenever you come with a mechanical patent, you should see that the components of the device or the implement is not merely rearranged. So you have to show that they are all connected yet to come out with the resultant function. So that is very important in case of the mechanical patent. I just give as a common example like a clock and a radio in a single cabinet, which can find their independent function. You need not put it in a single cabinet. So there should be interdependence of the components in the device or an implement to establish this property. A method of agriculture or horticulture is not patentable. So anything you do under the open land, any method is not patentable. And also the manual of patent office clearly says that even you can say that if I do it in a greenhouse, whether it is eligible. No. So they have some criteria to bring it out. So the cultivation of mushroom, they have given example, and the preparation of an improved soil using nematodes. So these are all not patentable in India. A method of treatment, again, see of the human being or animals, and you can see here the plant is an exception. So they say the method of treatment for the human being or the animals which make them free of disease or to increase their economic value is not patentable. See, if I come up with a method to perform heart surgery, it is not patentable. But if it is a cosmetic surgery, then it is patentable. See, in India, again, a plant as a whole, or animals, or a seed, variety, species, or any essential biological process, they are all not patentable. As I said earlier, microorganism is exceptional in the sense that it's not, you discover a microorganism, you can go for a patent. But if you come up with a genetically modified microorganism, where there you can prove there is a sufficient human intervention, then it is patentable. Mathematical methods are not patentable. Business methods are not patentable. Computer program as such, they are not patentable. In such a case, you have to go for protecting it under the copyrights. So I just want to explain how a computer program as such is not patentable. See, if it is embedded in hardware and it produces a technical effect, it is patentable. But as such, it is not patentable. See, you want to protect a source code and an object code alone, you cannot go for patent. You have to protect it under the copyright. Literary works, dramatic works, musical works, photos, all these are any artistic works, you have to protect it under the copyright. And method of performing a mental act or a method of playing game, like a method of teaching or a method of playing chess, these are all not patentable. Any presentation of information is also not patentable. Traditional knowledge. This is again important aspect under section 3D where you cannot go for a patent. See, traditional knowledge, like if I say that if I use turmeric, it heals the wounds, it's a traditional knowledge, so that cannot be patentable. But again, if I use that turmeric and I show there is sufficient human intervention, and then I come up with an ointment which has more efficacy, and then along with other excipients I add, and then it show that its effect is more than that, then it is patentable. This is one another section, section 4 of the Patent Act. This comes under section 4 of the Indian Patent Act, where they say that any invention which is related to the atomic energy, or they give very specifically that if it falls under 21 of the Atomic Energy Act 1962, it is not patentable. See, supposing your invention has isotopes, and then immediately they will refer it to the Atomic Energy Department. So it is always right when you draft the specification itself, you clearly say that it doesn't fall under the 21 of the Atomic Energy Act, so that your application will be taken up for the examination instead of diverting it to the Atomic Energy Department for approval. This is the crux of what I have been talking now. So this is a filter model developed by Dr. Kalyan of Banana IP. So what he says that, say you have a patent, you have the invention at the top, you want to get the patent. Just simple, it has to pass through these 5 filters. So what is the first filter? The first filter is the subject matter. Subject matter is that it should be a patentable subject matter. Say I listed out what are not patentable in India. So your invention should not come under that list. And second is that the usefulness or the utility of the invention. See, mostly 99% of the invention will have utility. I think this is easy to pass through this filter. And the third one is the novelty. So novelty is the newness of your invention. That it means that the prior use and prior publication should not be there before the filing your application. That is your own application also, and no such invention should exist before the filing in the world. You have to see that is important. And the fourth filter is the non-obviousness or the inventive step. Inventive step is that, as I discussed, you have to show, educate a technical advancement of your invention over the inventions in the prior art. And the final one is the specification. So specification is that document which we submit to the patent office. So we will see in detail about that now. So a patent specification, we call it always as a techno-legal document. So the scientific details of the inventions are mentioned in the specification. And we call this activity as a quid pro quo. It means something for something, because see, as the inventors, they disclose their invention to the government, and in turn they get the right, exclusive right granted by the government, which prevents the use of invention by the others. The specification, it has two types of patent has two types of specification. One is the provisional, the other is the complete. So what do I mean by provisional application? So the provisional application is filed by the inventors when the invention is at a conceptual stage. So, and you need time to work on it to get the entire details of it. In such a case, you can go for provisional. Why you go for provisional? Because to get the first filing date, which is called the priority date, because that is the important date before which your application will be determined for the novelty and the inventive state. So gaining the priority date is very much important. But no patent is granted on the base of the provisional, because once you file provisional, within 12 months, you have to file the complete specification. Otherwise, your application will be abandoned. Then complete specification. As I said, you can, once you file provisional, file complete within 12 months. What does the complete specification has? It has all the details of the invention. And you can go for a two-step process, or you can also go as a one-step, where in the first instant itself you have all the details of your invention. You can directly file the complete specification. You need not file provisional and then go for complete. You can directly file the complete specification. Patent has three main sections. The one is the cover page, then the specification, the third, the important claims. So what is a cover page? The cover page, it presents about the bibliographic information, and a specification describes the invention. The claims defines the scope of the invention for which the protection is claimed. And this is how a cover page of a patent looks. So you can see the bibliographic information about the patent. The application number will be there, when you have filed the application, when it was published, what is the title of your invention, and also all details about that classification. If you have filed in some other country and you file here, they will put the priority date also. And again, if you have filed international application, all these details will be there. And applicant, who is the applicant and who is the inventor, and also with a short abstract. So the nuances of the specification should be known, because that makes you to understand the patent clearly. So the specification, it has the following contents. So starting with the title, it goes to the field of the invention. Where the field of the invention, you have to grossly say where you feel, whether it is related to your biotechnology or it is related to an ECE or an electric. So you have to, and again in that also you can, if it is a computer, you can specifically write whether it is an artificial intelligence or ML, you have to specifically write. And third is that the specification will have the background of your invention. The background of the invention is very important. You have to say what are all the prior arts available regarding your invention, and then you have to clearly distinguish the how your invention is different from that in the prior art. We always call it as a white space. See, there is a space exists between the inventions which are already in the prior art and your invention. So what that white space you have addressed it, that should be clearly brought out in the background of the invention. And you have to state the objectives of your invention in the specification, and a summary has to be there, also an abstract should be there. And then if your invention is accompanied by drawings, you should give a brief description, and also you should attach the drawing sheets. And under the detailed description of the invention, you have to explain the invention in the best mode. See, normally people will say, no, I do not want to disclose. See, if you are not ready to disclose your invention completely, then all the way you have the blocks from the patent examiner and the controller not to get granted. So in best mode, we have to explain your invention. As I said, claims are the important part of the application. Claims define the scope of the legal protection, and so it should be drafted carefully. So drafting of claims is also an art and a science, and we say that there should be at least one claim in a patent application. So if it is not claimed, we call it as it is disclaimed, and it is open to the public use. So having seen about the specification, so we will now move to the important aspect of the patent filing mechanism. So this basic information about the patent filing is very much important. So now who can file a patent? A true and a first inventor, or the inventor would have assigned it to the some other person. So he is called as an assignee. So he is also eligible. And in case the assignee or the inventor dies, the legal representative can file it. So this again, they can do it alone, or you can have as also joint applicants or joint inventors are also there to file the patent. Where to file the patent? So you can file it in one of the patent offices that is determined by the territorial jurisdiction of the place of the office, or the residence of the applicant or the agent. See, there are 4 offices, patent offices in India. One in Chennai, Mumbai, Delhi and Kolkata. So we, the southern states, we have to file it in Chennai, and the western states, they will file in Mumbai. The northern states, they will file in New Delhi, and the rest of the states, they will file in Kolkata. How to file a patent application? So it can be done through online or through post, and also you can submit through and. So more than 90% is done online. So some clients or some applicants, they may not be able to do it through online, so they accept it post. And also and submission was taken away during COVID. Again, they have revived it. This is a general procedure to get a patent. First, file the patent application. So you have to wait 1.5 years to get it published. But there is also another mode called early publication. If you want to go through that, you have to pay extra official fee for that, and you can do that one. In such a case, your application will be filed, will be published maximum in a month. And there can be a pre-grant opposition. Pre-grant opposition is after filing, after publication and before examination. So it can be done, pre-grant opposition can be filed by any person. Any person is that you need not be the person in the skill of art. So it can be filed by any person. So once you file RFE, which we call it as request for examination, your application will be taken up for examination and it can be granted or refused. So if it is granted, it will be again published in the patent official journal. So based on the publication, again you can have a post-grant opposition. This should be done within 12 months from the date of publication of the grant of the patent. But the post-grant opposition is that it can be filed only by the person skilled in art. For example, I say that if you have a mechanical patent, so that person should have a degree in the mechanical engineering to file a post-grant opposition. And the final decision is taken by the controller, whether to revoke it or proceed to grant. What are the documents required to file a patent application? So main thing is the specification. So it can be a complete or a provisional. So which we normally put it on form 2, and form 1 we call it as an application form. Apart from that, the 2 important forms are the 3 and 5. 3 it gives a statement and an undertaking by the applicant. See, if he files in India and then subsequently he files in other foreign countries, he has to give an undertaking that he will inform the controller within 6 months. And declaration is by the inventor is important to prove that is inventorship. These forms, basic forms, will be accompanied by the required official fee. So what is the official fee? The official fee is 1,600 for an individual or for a small entity or for a startup, and also for educational institution. Like they have drastically reduced it. It was in this column. It has come to this column in, I think, in more than 1.5 years. I think it has. They have put 80% of the fee has been reduced to expedite the innovations in the academic area. So they have reduced the fee. And this is for 30 pages of the specification and 10 claims. So if you draft a specification more than 30 pages or more than 10 claims, you have to pay the extra fees accordingly. So having seen the first IP tool, a significant IP tool of patent, then we will move to the industrial design registration. So the industrial design, as I told already, the patent protects the utility or the functional value. The design protects the aesthetic value. So it can be a shape, or it can be a configuration, the arrangement of the parts, or it can even be a pattern, or it can be an ornamentation on the articles. It can be lines, colors applied to any article. It can be in 2 or 3 dimensional, but it should be by an industrial process, and it should appeal to, and this is judged solely by the eye. What are the requirements for a design registration? As I said, for patent, it should be novel, it should have inventive step, it should have industrial application, it should not fall under the section 3 and 4 of the Indian Patent Act. We have also the essential requirements for design registration. The first one is that it should be original, not copied. Okay, well, it should not have been disclosed in the public anyway. So it is similar to the novelty of the patent. So it should not be in the public domain before filing your application, and it should be distinct. Distinct is it should be distinguishable from the existing designs. Again, it should be applied to an article and it should appeal to the eye. It should not have any scandalous or obscene matter. It should not be contrary to the public order or the morality, and it should not be prejudicial to the security of India. Excluded from the scope of the design. A book, a calendar, label, cartoons, and again in any principle or mode of construction of an article, buildings and structures, architectures, they are not under this. Again, a part of the article which is not manufactured and sold separately, which you cannot do that one, they are not under this design registration. And variations, workshop variations, as I said, the alterations, and change in size is not eligible for, change in shape is eligible for design, change in size is not eligible for. Suppose you have a bottle with a different shape, you have, like it is already there in the public domain as an 1 liter, and just you have made it to 500 ml, so it is not eligible for the design, it doesn't come under the scope of the design registration. And any flags, emblems or signs of any country, and again the layout designs of IC, which we already discussed, that it comes under a separate IPR of SACLD, and so it is not covered under the industrial designs. Who can apply for a design registration? See, any person can apply, or a legal representative. If the individual person or something happens to them, it can be done through a legal representative, or if he has assigned it to some other person, an assignee can also apply for design registration. So here under the Design Act, the person includes, it can be an individual, or it can be a firm or a partnership firm or a small entity or a startup or a body corporate. So in 10 steps, you can get your design registered. The first step is that you should see whether any registration already exists. So like we do a patentability search to determine the novelty and the inventive step for a patent. Similarly, before going for registering your design, you see that whether such design already exists in the public domain, because then it becomes a duplicate where you will not be eligible to get your design registered. So this normally is done by searching in the design databases available in the internet, or you can even write to the design office and then you can ask them like whether such design already exists. Second is that here you have to prepare a representation sheets based on the device. So that includes a different views of your design. So you have to provide a minimum of 4 views to the design office, like an isometric view, a perspective view, top view, bottom, left, right, lateral view. So these are some of the views of your the design should be submitted to the design office. The third important aspect is that you have to identify the class of the design. See, under Locarno classification, there are 32 classes. So supposing you have come with an article of a motorcycle or a cycle, then it belongs to the class 12. So identification of the class is very, very, very important. Or you have developed a different router in the computer, then the design, it can be protected under the class 14 of the Locarno classification. So that is very important. Then once you prepare the representation sheet, you have to provide a statement of the novelty in the sheet. So where the novelty lies, whether it lies in the shape or whether it lies in the configuration of the article, this is very important to be stated. And it should also be accompanied by a disclaimer. The disclaimer is that, see, already I shared that any functional value, the construction of an or the mode of operation, these are all not protected under the design. So you have to include, and again, if your design has some trademarks, so it is not included in the design registration. So you should provide a disclaimer that you are not covering those things in your design registration. And then claim a priority date. Priority date, as I said, it's a first filing date. So this normally is done. See, when a person is already filed in foreign and then he comes, he wants to protect his design in India also. In such a case, he will claim the priority date. And what is the fee that has to be paid? You determine it. Then ensure all enclosures are attached. So these enclosures normally come when you file it through a attorney. So power of attorney is very important to be given to them. And if you have, again, if you claim a priority date, all priority documents have to be attached. Then this is complying with objections is that once you file, if there are any form, they first scrutinize your application formally. So any formal objection, not they don't go through the technical objection. So they see the any formal objection is there, they immediately send a mail to you. They ask you to correct and send it immediately. So if you comply with all those objections properly and then you provide the whole details, you can get your design registration very fast. See, we got design registered in 3 months for an engineering college, and also for a startup, we got it approved, a biotech startup, we got it approved in 45 days. So by following this 10 steps, you can enhance the process of getting your design registered fastly. Again, where to file your design application? So you can file in any of the 4 patent office, Delhi, Mumbai, Chennai or Kolkata. But you have to note that the prosecution of a design application happens only in the Kolkata office. What are the benefits of design registration? As I shared about patents, again, this design registration, it gives you an exclusive right. The very important thing is that, see, whenever your design or any IPR is infringed, only the registration certificate is a document that can be produced before the court. So to justify that you are the authorized owner of your design. And again, when you want to commercialize it, either you want to license it or you want to sell your design as a legal property and for a consideration or a royalty, the registration is very, very important. The official fee for filing a design in India is that any individual or a startup or a small enterprise with 1,000 rupees of an application fee, you can go ahead to file it, and others they have to pay 4,000 rupees. I will now share the live examples of the industrial design registered and different branches of the engineering. So the first one, if you see, this is an antenna. So I think it comes under ECE. So you can see the different shapes of the antenna got registered under the industrial designs. And this is related to computer engineering, and you can see a laptop, the design is registered, and this is a different monitor, shape monitor, they have got it registered, and a mouse, a router. So different designs of the computer accessories or the parts, they all get registered in the under class. I think it comes under the class 14. Yeah, with the 14 and the 14 you have to get registered the different computer parts. And I said, like, if you have developed a new design of a motorcycle or a cycle, you can go and get registered under the industrial designs. I think it comes under the class 12 of the Locarno classification. And the parts of the vehicle, see, you can see the back bumper, the hub cap, the wheel rim, they have all been registered. This is related to electrical engineering. See, this is, I think it's a socket and it's a switch, it's a connector, they have got it registered. These are all the different designs of the switches or the sockets or the connectors. And again, an environmental engineering, where now many types of smart bins have been developed and designed and developed, so they have its place in the design registration. And this is related to biotechnology. You can see an LCD display with trinocular digital microscope, and this is related to a biosensor, and an incubator, a different design of an incubator is registered. And also the COVID instruments or the devices or the accessories, they have also found a place in the industrial design registration. So I would like to end this session, leaving this thought to you. And I was asked to tell about on technology commercialization. So normally you have a technology and you got it protected through a patent or a design. So you have you can commercialize it mainly through two modes. The one is that you can one is that assignment, and the second is licensing. So what is assignment is there is a huge difference between assignment and licensing. Assignment is that you sell away your rights completely. You don't have a hold on it once you assign it to the other person. The rights have been sold away, but you will get a lump sum amount as a compensation or as a consideration. But that is not the case in licensing. The licensing is that you can do an exclusive licensing for a specific period only to a specific person, or you can do an inclusive licensing where you can include many persons. You can give the technology to many persons in many, and also in many in countries also you can do that one. So these are the normally the two modes where the people try to commercialize their technology. And now the session is open to receive the questions from you, and I expect a lot of questions so that we can have a healthy discussion on what we have understood on the patents and the industrial designs.
Thank you, ma'am.
Thank you very
Then
much.
they will be posting the questions to us. So okay, I will get back to you because they don't have option of this chat and all. We are just telecasting.
Please,
in the
yeah,
seminar.
you can do that one. Yeah.
I'll get back to you with the questions, ma'am.
Sure.
Ma'am, so on behalf of the principal, HOD, staff and students of Department of Biotechnology and EC, we extend your heartfelt gratitude for accepting our invitation and giving such a wonderful talk. Thank you, ma'am. Thank you once again.
It's my pleasure and honor to share my knowledge and experience with you all in this session.
Thank you. Thank you so much.
Thank you.